Hi, I'm Greg McIntyre with McIntyre Elder Law. I wanted to talk about today NC General Statute 28A-24-2, requirements of survival by 120 hours. So this is a little known and little discussed part of the law that affects how assets are distributed to beneficiaries or heirs when someone passes away. And what it essentially says is that, and I'll read the statute and I'm going to tell you what I think it means, okay? Subsection A, except as otherwise provided in this article, where the title to property, the devolution of property, the right to elect an interest in property, or any other right or benefit depends upon an individual's survivorship of death of another individual. An individual who is not established by clear and convincing evidence to have survived the other individual by at least 120 hours, so that's 5 days, is deemed to have predeceased the other individuals. So that's huge. That means someone that you have as an heir in your will, or a beneficiary on a life insurance policy, or a joint account holder on a bank account, or let's say they're receiving real estate. If they pass away within a 5-day window of you passing, so if one individual passes, he has his estate plan set up, or she has her estate plan set up, and then one of the beneficiaries or heirs passes within that window, then the heir, the beneficiary, is deemed to have predeceased the testator or the person that was passing the assets, which would change the distribution of the assets. I wonder how many, title searches are being done out there that this affects on real estate, or people who might have an interest in property and do not know about it. If the language of the governing instrument disposes of the property in such a way that two or more, so if it's more than just the one person that predeceased, two or more beneficiaries are designated to take alternatively by reason of surviving each other, and it is not established by clear and convincing evidence that any such beneficiary has survived any other such beneficiary by at least 120 hours, the property shall be divided into as many equal shares as there are alternative beneficiaries. So that means that person's share, instead of going down to, say, their children, the beneficiary, instead of it going to their children, it would go to the other beneficiaries or other heirs equally. If there were, say, two other beneficiaries, they would split that third of the beneficiary that died within 120 hours of the death of the original person, the principal or the testator. It would split it among the other two. And these shares shall be distributed respectively to each such beneficiary's estate. So that's huge. That could mean that a conveyance of real estate really didn't go into this person who deceased within 120 hours. And this is something that I don't think we as attorneys or courts or in doing real estate title searches really pay that much attention to. But I wanted to make you aware of it. It's been called to my attention and I wanted to look at it. Hey, I'm an estate planning and elder law attorney at McIntyre Elder Law. And all we do is estate planning and elder law. If you have any questions about drafting your will, about setting up a trust, about naming beneficiaries, or just need some review of documents and guidance, give us a call. You can call 704-749-9244, or you can go online and schedule at one of our 3 offices at mcelderlaw.com, mcelderlaw.com. We have offices in Charlotte, Shelby, and Hendersonville, North Carolina, and we would love to serve you. Thank you.